defaming and committing sexual battery against E.G. and Carroll. In these cases, you represented the president in his personal capacity. If a case comes before you in which President Trump's personal interests are heavily implicated, will you recuse yourself?
Senator, I've been very proud to represent the president.
Well, will you recuse yourself?
I will recuse from any case I've been personally involved in. For any other case, I would consult the judicial canons and the appropriate recusal rules. I may need to consult with my colleagues.
Well, considering the kind of representation that you've provided, President Trump, you do cite the canons of ethics and the Code of Conduct for United States judges requires a judge to disqualify himself, quote, in a proceeding in which the judge's impartiality might reasonably be questioned, end quote. I would say that in any case involving President Trump's personal interests, you should recuse yourself because it is very clear where your loyalties lie. Thank you, Mr. Chairman.
Senator.
In today's breakdown, we are plunging directly into the heart of a political earthquake on the U.S. Senate floor, an explosive showdown between Senator Mazie Hirono and John Smith, a federal judicial nominee personally selected by Donald J. Trump. Within the span of a single tense hearing, Mr. Smith laid bare a terrifying degradation of our justice system, exposing three critical flaws. First, the deafening silence and flat-out refusal to explain the woke ideology catchphrase he weaponized to fire up conservative voters. Second, the cowardly, ambiguous dodging when asked to recognize the insurrectionist motives behind the January 6th Capitol attack. And the ultimate breaking point, his failure to explicitly pledge recusal from any future cases involving Donald Trump, despite previously serving as the former president's personal lawyer in a civil sexual abuse trial. Why does this standoff represent an existential threat to the nation? Consider this: a president's term expires after 4 or 8 years, but a federal judgeship is a lifetime tenure. The individuals elevated to these benches wield the absolute authority to mold society, granting or dismantling the fundamental rights of millions of Americans for the next 3 to 4 decades. Such unparalleled power requires uncompromising independence. Yet, what we are watching unfold is a chilling moment where a man aspiring to become the ultimate arbiter of justice would rather ignore historical reality and compromise ethical boundaries than risk crossing the former commander-in-chief who gave him the nomination. Let's cut straight to the unedited footage and break this down, piece by piece. The clash ignited when Senator Hirono resurfaced the highly partisan op-ed that Mr. Smith published on Breitbart just a few months prior, July 2024, urging a crusade against what he termed the woke ideology. Pay close attention to how the senator springs the trap and watch the nominee scramble.
No.
Mr. Smith, on July 30th, 2024, you wrote a post on Breitbart endorsing a Missouri Attorney General candidate. Do you recall that post?
I do, Senator.
So in that post, you wrote, quote, Republican attorneys general are critical in the fight against the radical left. We need true conservatives to defeat the abortion industrial complex, the lawlessness plaguing blue cities, and the woke ideology invading our schools, end quote. Can you define the word woke?
Senator, I was very proud to support my friend who was running in that election. That was a piece of political advocacy, and as I was explaining to one of your colleagues earlier, the partisan views or political activity I've had before would play no bearing on my role as a judge.
Well, you're not responding to my question. Can you define for me what constitutes woke ideology? You wrote it. You meant something. I'd just like you to tell us what you meant by that.
Yeah, Senator, in the course of a political campaign, that was a piece that I put out in support of my friend. But as a judicial nominee, I don't think it's appropriate for me to start commenting on political views because as
a casual observer might assume Senator Hirono is simply aiming to humiliate the nominee. In reality, she is laying down a fundamental stress test for judicial honesty. Why did she corner him on the definition of woke? She made the context incredibly clear. The former president issued executive mandates designed to gut DEI, diversity, equity, and inclusion initiatives across the federal government. Countless legal battles concerning workplace discrimination, civil rights, and educational policies will inevitably land in federal courts, heavily featuring terms exactly like DEI and woke. If a prospective judge openly characterizes this on a partisan platform as an ideology invading our schools that needs to be defeated, how can we expect him to be a neutral arbiter in a civil rights lawsuit? Beyond that, witness the sheer intellectual cowardice on display. A judge's entire profession relies on the meticulous dissection and exactness of legal terminology. Every single word in the Constitution carries life-altering weight. Yet, this nominee casually tosses around an incendiary political dog whistle to score points, only to shrink away from defining it under congressional oath. His deflection confirms the obvious. He knows the phrase lacks any actual legal substance. When a nominee leverages hyper-partisan rhetoric to boost his profile, but hides behind the guise of judicial impartiality to avoid defending those very words, he surrenders any claim to true independence. Following her exposure of Smith's hollow rhetoric, Senator Hirono doesn't give him a moment to recover. She pivots to a far more consequential dilemma, a nominee's capacity to acknowledge undeniable facts. The events of January 6 are not up for political debate. It is a documented historical reality cemented by hundreds of federal convictions. Yet, watch how this prospective federal judge responds when confronted with a basic, irrefutable truth.
The electoral votes on January 6th. Do you acknowledge that rioters on January 6th sought to stop this process to prevent Joe Biden from being the president? If that's a yes or no question.
So I understand that the counting of electoral votes was interrupted on January 6th. I want to be very careful in getting beyond too much further beyond that because there is still active litigation.
I think it's pretty clear what the rioters' intents were, and in fact, if you don't want to, you won't answer that straightforward question. I have another one. Do you also acknowledge that a number of these rioters, some 1,500 or so of them, were convicted, and that President Trump pardoned them? Do you acknowledge that fact? Yes or no?
This exchange represents the most institutionally terrifying segment of the entire proceeding. It goes far beyond mere partisan allegiance. Senator Hirono is demanding that he validate realities already decisively proven in courts of law. 1,500 individuals were found guilty of rioting and interfering with congressional proceedings. Yet, he minimizes the insurrection as a mere interruption of the counting of electoral votes and hides behind the shield of active litigation to avoid acknowledging the mob's true objective. This kind of dodging isn't a sign of legal restraint, it is a display of absolute political subservience. Why should this terrify us? The fundamental duty of any judge is to weigh evidence and declare the truth. If a nominee refuses to look squarely at the judicial track record of the very institution he hopes to join and acts as though the facts are still debatable simply because the truth looks bad for the man who appointed him, how can the American people trust him to handle infinitely more complex legal disputes? When Hirono corners him into admitting that Trump issued pardons to these convicted rioters, his stammering, I think that is what happened, reveals a man gripped by panic. He is caught in a vice between an indisputable legal fact and the paralyzing fear of angering the political force controlling his professional destiny. This is exactly how the justice system loses its grip on objective reality. Hirono then circles back to the jaw-dropping moment we highlighted at the very beginning. She makes it clear that John Smith is not an ordinary candidate. He shares a direct, highly personal attorney-client bond with the president.
So, Mr. Smith, you have represented President Trump in multiple lawsuits in which he has been found liable for defaming and committing sexual battery against E. Jean Carroll. In these cases, you represented the president in his personal capacity. If a case comes before you in which President Trump's personal interests are heavily implicated, will you recuse yourself?
Senator, I've been very proud to represent the president
Well, will you
in those
recuse
cases.
yourself?
I will recuse from any case I've been personally involved in. For any other case, I would consult the judicial canons and the appropriate recusal rules. I may need to consult with my colleagues.
Well, considering the kind of representation that you've provided, President Trump, you do cite the canons of ethics and the Code of Conduct for United States judges requires a judge to disqualify himself, quote, in a proceeding in which the judge's impartiality might reasonably be questioned, end quote. I would say that in any case involving President Trump's personal interests, you should recuse yourself because it is very clear where your loyalties lie. Thank you, Mr. Chairman.
Senator.
This is the undeniable focal point of judicial capture. The Code of Conduct for United States judges lays it out without ambiguity. A judge is required to step down from any proceeding where the judge's impartiality might reasonably be questioned. Having acted as the personal defense lawyer for the president in a highly publicized sexual abuse lawsuit is the ultimate textbook example of a conflict of interest. Rather than offering a firm, unequivocal yes to safeguard the court's legitimacy, he states he is proud and pledges only to consult the rules. That response establishes a catastrophic precedent. It signals that these nominees are being placed on the bench not to uphold the Constitution, but to serve as permanent, lifetime legal armor for their former clients. What we have just unpacked together is far more than a dry congressional hearing. It is a meticulous blueprint of how democratic institutions are dismantled from the inside. The collapse doesn't begin with a military coup. It begins with men in black robes occupying federal courtrooms whose allegiance to the Constitution has been quietly swapped for blind loyalty to a single politician. It starts when concrete historical facts are brushed aside as ongoing litigation, and when the absolute requirement of legal impartiality is downgraded to a mere guideline to be consulted. Senator Mazie Hirono wasn't merely grilling a nominee, she was carving a permanent record into history, demonstrating that the lawmakers greenlighting this degradation are entirely aware of the damage they are causing. If you have watched until this point and grasped the gravity of this breakdown, you are precisely the audience this channel was built for. If this deep dive brought you value, please smash the like button so the algorithm pushes this critical analysis to a broader audience. I want to hear from you down in the comments. What do you think about Smith using the consult the rules loophole to avoid recusal? I'll be reading every single one. Make sure to subscribe and ring the notification bell because we will never stop stripping away the facade and exposing the raw truth behind Washington's corridors of power. Thanks for tuning in, and I'll see you in the next one.
The fact that 8 U.S. senators, figures holding supreme legislative power, had their personal telecommunications data secretly extracted goes far beyond the scope of a standard political scandal. This is, in fact, a crisis centered around the limits of power and the separation of branches within the government. A federal executive agency did not hesitate to apply the most rigorous surveillance measures to interfere in the private lives of lawmakers, bypassing minimum transparency. More notably, this very massive and proactive apparatus suddenly turned into an evasive, passive entity when having to deal with the list of high-ranking figures linked to Jeffrey Epstein's criminal network. Today, we will dissect one of the landmark hearings regarding the transparency of the U.S. justice system. By erecting sharp legal barriers, Senator John Kennedy stripped bare the deep contradictions within the Department of Justice, DOJ, cornering Attorney General Pam Bondi into a dilemma. Opening the questioning, Senator Kennedy did not resort to direct accusations. He chose to force the Attorney General to personally reaffirm the strictest constitutional regulations regarding the subpoena issuance process, only to then expose the concessions made by tech conglomerates, big tech, in protecting user rights. Let's follow this airtight argumentative tactic.
And you would have to have cause.
I'm sorry, what do I have to show?
You would have to have cause to get the
Good
subpoena.
cause or probable cause?
Probable cause.
Okay. Probable cause, or if it's a subpoena duces take them, good cause, to show what?
You would need good cause for a subpoena duces tecum, and what you would have to show is that you believed a crime had been committed, or there was a possibility of a crime, or that could lead to other crimes. We frequently, in criminal enterprises, subpoena cell phones.
By the sitting United States Senator.
Senator, they would have to have believed you were part of a criminal conspiracy, is my understanding.
Would a judge have to sign off on it? on the subpoena?
Yes, Senator. Well, for a subpoena ducis tecum, Jack Smith probably took it straight to the judge.
Now, the phone companies, particularly their general counsel, if they're worried about civil liability, even with a subpoena to get the phone records of a sitting United States senator. Did I mention it was a sitting United States senator?
Yes, Senator.
The general counsel for that phone company, let's say AT&T, they have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
Yeah. And a smart general counsel for that phone company is going to call the sitting United States senator and say, would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States senator. Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime. Again, I can't comment on details of this particular case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator Kennedy.
But let's suppose, okay, they didn't want to tip off the sitting United States senator. But the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, you know, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States senator. So general counsel would likely.
The dialogue sequence above is a prime example of constitutional law interpretation. Every telecommunications corporation maintains a large-scale legal team, and their lawful defense tool is the motion to quash face with the demand to provide the sensitive data of 8 senators, an event Kennedy deemed as serious as 4 heart attacks and a stroke. Professional ethics mandate that these lawyers activate this legal blocking mechanism. Despite this, the absolute compliance of these corporations in handing over all data has set an extremely risky legal precedent. When the private sector accepts backing down to the state unconditionally, the barrier protecting the privacy of ordinary citizens can also be considered completely collapsed. The existence of a democracy depends fundamentally on the principle of accountability. Whenever state agencies utilize intrusive power, they are obligated to maintain a transparent documentary system. Observe how the DOJ representative responds, along with the stern warning from Senator Kennedy regarding the impending legal consequences.
Now, do you have copies of the subpoena applications for these
Senator,
8?
Senator, I can't discuss anything regarding this.
You can't even tell me if you have copies?
I can't discuss any of this.
All right, when are you going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator.
but
This was
let's
just
assume
brought to light
if
by
there is a
Director
pending
Patel.
investigation, I don't want this to get swept under the rug, okay? Because I think you're going to get pushback from all quarters. I think the telecommunication companies are going to be all over you like a bad rash because they've got liability here for just turning over these records when they knew what was going on. I think some FBI agents may have some liability here. I think a special counsel might have some liability here.
The situation of citing investigative confidentiality to evade fundamental questions is an alarming phenomenon. Kennedy emphasized a crucial point. This act of concealing information does not stop at the boundaries of political morality. It also entails massive legal risks, liability for the telecommunication carriers, FBI agents, and even the special counsel. When a powerful institution refuses to publicize its own internal decisions, it is a sign that the agency is operating outside the framework of the law. Entering the second half of the hearing, Senator Kennedy executed a strategic pivot, unmasking the double standard in how the DOJ determines its investigative priorities. He reopened the files on Jeffrey Epstein's criminal network, presenting verbatim quotes from a cabinet-level witness, the sitting U.S. Secretary of Commerce, Howard Lutnick.
Secretary Howard Lutnick on October 1 gave an interview to the New York Post. about Mr. Epstein. And he described Mr. Epstein as, quote, the greatest blackmailer ever, close quote. Have you reviewed that transcript of that interview?
I have not reviewed the transcript, but I saw the clip of it.
Okay. It appears that Secretary Lutnick was Mr. Epstein's next door neighbor. In fact, their townhomes shared a wall. And the reporter that was talking to Mr. Lutnick, she asked how other prominent men could have been associated with Epstein when Mr. Lutnick could immediately sense that he was a, quote, pervert. And then Secretary Lutnick said, or rather the reporter said, did they see it and ignore it? Do you remember that from the interview?
I do.
And Commerce Secretary Lutnick said, no, they participated. And then Commerce Secretary Lutnick goes on to say, quote, that's what his MO was. You know, get a massage, get a massage. And what happened in that massage room, I assume, was a video. This guy was the greatest blackmailer ever, blackmailed people. That's how he had money, end quote. Is that true?
It must be reaffirmed. These are absolutely not baseless rumors. This is a public statement from a billionaire with direct access to the elite, someone who was once Epstein's next-door neighbor. When Mr. Lutnick asserts that prominent figures did not just condone but directly participated, only to be recorded as blackmail material, this constitutes extremely weighty legal witness testimony, demanding immediate action from the authorities. The foundation of investigative work is not to overlook any credible source of information. Even so, the DOJ's response to these systemic allegations showed an enormous disparity in standards. The final segment of this questioning is the verdict exposing the responsibility-dodging attitude of America's most powerful investigative agency.
Senator, as our July memo said, we did not uncover evidence. This case has gone through 3 administrations, as well as former U.S. Attorney Alex Acosta.
I know that, Pam, but have you interviewed Secretary Lutnick?
No, Senator.
Do you plan to?
If he wants to talk to the FBI or the FBI wants to talk to him, that is more than on.
Don't you think you ought to talk to him after this interview?
Senator, if Howard Lutnick wants to speak to the FBI and if Director Patel wants to speak to Howard Lutnick, absolutely.
This is an unjustifiable contradiction. The rationale that 3 administrations and hundreds of millions of budget dollars have been exhausted but found no evidence completely collapses when the FBI has not even once proactively approached to interview a crucial witness who is ready to provide information when handling internal political targets, such as extracting senatorial data. The Justice Department shows a fierce proactiveness in clearing all hurdles. However, when faced with a blackmail network linked to the upper class, this giant executive machine chooses a passive approach of waiting for the witness to come to them. This action does not reflect a weakness in professional capability, but rather a deliberate decision to turn a blind eye. Through the proceedings of this hearing, we have witnessed a fracture in the core values of American institutions. When privileged agencies can freely bend the rules to interfere with the data of lawmakers, while simultaneously exhibiting a cover-up attitude toward organized crimes at the highest levels, public trust in the justice system will undoubtedly be severely damaged. This incident poses an urgent demand for the creation of truly independent oversight mechanisms, conducting a comprehensive audit of the DOJ's subpoena application process, coupled with the demand to declassify records related to the Epstein network, is not merely a legal requirement, but a mandatory foundation to restore the fairness of the entire system. How do you evaluate the inequality in law enforcement exposed in this hearing? Does the current system have the capacity to self-correct, or does America need a broad-based institutional overhaul? Please share your analytical views in the comment section below. Do not forget to subscribe to the channel to continue following our in-depth commentary bulletins. Goodbye, and see you next time.